Dear students, we are continuing with the revision of the chapter Decision Making System of a Company. We have covered the introduction and section 101, which is Notice for a Meeting. Today we will be discussing Agenda, its meaning, objectives, and nature, section 103, which is Quorum, its meaning and provisions, section 105, which is Proxy, its meaning and provisions. Moving on to our first topic for the session today, which is Agenda. What is an agenda? The list of tasks to be handled in its order in the meeting is called an agenda. In simple words, agenda is the points that are going to be discussed in the meeting. It sets out the list of items that are going to be discussed. Agenda is either included in the notice or is attached along with the notice on the next page. It is important to note that the agenda should include the purpose of the meeting, that is, why is the meeting being called, and in which order the matters are going to be discussed so that no point is left out. Next, we learn what are the objectives and nature of agenda. The agenda can be written in normal form or in detailed form. The normal form includes the broad activities of the meeting with space on the side to note down important points during the meeting. The detailed form includes the entire description of the activities that are going to be discussed. For example, there are financial irregularities of company accountants. The whole detailed description will be given so that the people receiving the notice understand the entire story before they attend the meeting. Moving on to the objectives of the agenda. The agenda is given in advance so that the members are informed about the matters that are going to be discussed. They can discuss the matters with other knowledgeable people and bring meaning to the meeting. Having an agenda helps the meeting to be conducted in a systematic order. The first point is discussed first, only then they move on to the second point. And the order needs to be maintained. You cannot discuss the last point first and vice versa. Agenda ensures no point is left out or omitted. Next, we see an example of the notice and agenda. Recollect the mnemonic that we learned for the content of notice? DDTPM. Day, date, time, place, and matter. Next, we understand section 103, which is quorum. What do you mean by a quorum? The answer is, for statutory tasks to be carried out in the meeting, the minimum number of members required to remain present in the meeting is called a quorum. Decisions in a company can't be taken alone, and hence for a meeting to be considered legal, a minimum number of members are required to be present. That is a quorum. If the quorum is not formed, decisions taken will not be considered legal. Also, from the beginning to the end, the quorum should be maintained. Moving on to the provisions, we shall cover these provisions in the form of a question and answer round. Okay, so let's see what's the first question. The first question is, how many members make a quorum? For a private company, minimum 2 members are required to form a quorum. For a public company, having 1000 members, minimum 5 members are required to personally attend the meeting to form a quorum. If the public company has 1000 to 5000 members, the minimum numbers required is 15. That is, 15 members need to attend the meeting. If the public company has greater than 5000 members, minimum 30 members require to attend the meeting. These are the minimum numbers given by the government or the Companies Act. The company can increase this minimum number required to form the quorum if they state it in their articles of association. Next, moving on to the second question. How many directors will make a quorum? If the directors have not fixed the minimum directors required to form a quorum on their own and mentioned it in the articles, then 1/3 of the directors or 2 directors, whichever is more, will be considered to make a quorum. It is important to note, if the quorum is not formed within 30 minutes of the scheduled meeting time, then the meeting is postponed or adjourned. Then what will happen? When will it be postponed to? The meeting will be conducted in the next week on the same date, same time and same place. What happens if on the postponed date also the quorum is not formed? If then also quorum is not formed, what will the answer be? Then the members who are present will be considered as sufficient and the meeting will proceed and will be considered legal. Next, we have a small quiz. The first question is, a meeting started with a quorum, but soon some members left and the quorum became short by the end. Is the meeting considered valid or invalid? The meeting will be considered invalid, as the provision states that the quorum should be maintained from the beginning to the end. The second question is, a meeting was convened and the quorum was not formed, so the meeting was adjourned. The adjourned meeting also quorum was not formed. What will they do? Will the meeting be adjourned again? The answer is, all those members who are present will be considered as sufficient and the meeting will proceed and continue and it will be considered as legal. They need not adjourn the meeting for the second time. Moving on to question 3. Suppose 2 people are holding 1 equity share. You have a joint holder. Both of them will be included to make a quorum. Taking an example, in a public company with more than 5000 members, the minimum 30 members are required. Suppose there are 28 members present and 2 additional members come in who have 1 single share. Will the quorum be formed? The answer is no. The quorum won't be formed because here the joint holder of 1 equity share will be considered as 1 vote only. Having 2 people will not make 2 votes. You need to have 2 equity shares or more shares to have more votes. Joint holders will be considered as 1 and not 2. Moving on to our next topic, which is section 105, proxy. What do you mean by a proxy? A proxy means an authority to represent and vote for another member in a meeting. When the member himself or herself cannot attend the meeting, then they send their representatives. An easy example is when you mark proxy attendance for your friend. The friend is not present in class, but you mark his or her attendance. You are your friend's representative. Next, it is not necessary for a proxy to be a member of the company. The proxy also does not have a right to speak in the meeting. The proxy can only vote. Moving to the provisions. We shall cover the provisions of proxy through a question and answer round. The first question is, who can be appointed as a proxy? The answer is, an individual or a person. A robo, a partnership firm, an HUF, etc. cannot be appointed as a proxy. The person or individual may be a member or may not be. It is not necessary for the person to be a member of the company. Second question is, can the proxy give his or her views? No. The proxy cannot participate and express their opinions. They can only cast their vote. The third question is, how many proxies can be appointed? The answer is, the members can only appoint one proxy. The document of the proxy holder should also be given in written in advance. The fourth question, are proxies counted in the quorum? Proxies nominated by the individual members are not counted in the quorum. So, to make a quorum, you require the members of the company. The proxy members will not be counted. Moving on, there are some rules framed by the Supreme Court of India on proxy. The first one is, a minor cannot be appointed as a proxy holder. A minor in India is considered as a person who is below 18 years. The second, if a creditor company is sending a proxy to attend the meeting, then 48 hours before the meeting, they need to dispatch a copy of the resolution and also a copy of the proxy form. For a public company, the members appointing proxy holders need to submit their letters before 48 hours of the meeting. This is an example of a proxy form. It states the number of shares that the holder has, the address that the proxy is an example of a proxy form. It states the number of ordinary shares that the shareholder holds, the name and the address of the proxy appointed, and whether the shareholder is giving the proxy permission to vote on his behalf. That's all for today's session. Thank you and have a good day.